Okay, we have spent this segment learning about the allocation of authority between the levels of government, state, federal, and the branches, judicial, executive, legislative. So now let's talk about the interplay of these things. How do they work together? Let's start with a quick review on the basis for regulation. So when we have a clash, we can understand what's going on. Now, again, right below me, we're going to take it right back to the Constitution. Everything starts with the Constitution when it comes to governmental authority, because that's where the power flows from. It's our founding document of our country. So if you recall, the Constitution establishes a federal government and enumerates very specific powers that say exactly where this federal government can regulate the authority that it has. So there were the enumerated powers, things like tax and spend, raise armies, protect intellectual property is one, so that's why the federal government controls patenting. But they included this Commerce Clause, the power to regulate interstate commerce, the movement of goods or people or business across state lines. And if you recall, this Commerce Clause has really been used to stretch the authority of the federal government into areas far beyond those enumerated powers. So, for example, the federal government can regulate minimum wage and employment in every single state in the country. How is that possible? It's because they wrote the law to apply to any business that is involved in interstate commerce. So if they sell their goods in interstate commerce, or if they get their supplies from interstate commerce, if they use materials or equipment that is involved in interstate commerce, if you are a baker, remember, and your oven came from a different state, that ropes you into interstate commerce. And so, again, this has been used to really allow the federal government to regulate in places like healthcare or employment, environmental places, things that are not specifically listed in the Constitution's enumerated powers. So the Commerce Clause allows them to do quite a few things. And if not, they have the necessary and proper clause, which is referred to as the elastic clause. It is listed in the enumerated powers, and it says that Congress can pass laws that are necessary and proper to carry out legislation in some of the listed areas. And so again, this has allowed them to legislate in areas or on issues where they're not specifically listed in the Constitution. And finally, there's the Supremacy Clause that says the Constitution is the supreme law of the land, that federal law trumps state law where they conflict. And we'll talk a little bit more about what happens when these laws conflict in a second. But before that, let's not leave out the states. So the states get their authority from the 10th Amendment of the Constitution, which says anything not explicitly given to the federal government is the province of the states. So the states can act in these limited areas. That's why the federal government is thought of or referred to as a government of limited powers. Not so limited, but laws have been knocked down because the Constitution, the Supreme Court has found that it's outside even this really broad scope. But states get a lot of latitude to regulate. So if it has not been given specifically to the federal government, exclusively to the federal government, the states can have it. And so you see the states regulating in pretty much any area that they want to, except for a few that we'll talk about in a minute. But that's going to look more like your local type of authority. Police powers, the power to keep people safe, the power to protect the public health, education, and then matters that are just solely inside the state. So property law matters, transportation, to the extent that it's inside the state, like operation of vehicles inside the state. Those kind of things are going to be left to the state governments. Now, that being said, there are some what we call concurrent powers, places where both the federal and the state government can act, or things they can do. For example, both the federal and the state government are allowed to tax and spend. It would be impossible for the state government to do anything without money. So it has the power to tax its residents inside of its state and spend that money inside of its state. Environment is another situation. The federal government has its own laws on environmental protections that go across the entire country. The Clean Air Act, the Clean Water Act, that is nationwide. But states also have the power to regulate pollution inside of their own state as well. So there are some areas that are concurrent, and both can, the state and the federal government can regulate there so long as the laws don't conflict. So what happens if they conflict? Let's talk about that. So when the laws conflict, we'd say that there is preemption. And this means the federal law overrides the state law. And this comes from the Supremacy Clause again. So there are several types of preemption. This is how we know when a federal or when a law is in conflict. So an example, or preemption can be express. So the federal government can regulate in an area, and the law that they pass might explicitly say that they are preempting state governments. So this is, the state government is not allowed to act. It's not going to be like environmental law, right? Where, hey, we're going to pass some environmental protections and the state can pass some environmental protections too. No. When a law expressly preempts the states, Congress is saying you are not allowed to legislate in this area at all, and they block out the states. So an example would be the purview of the FAA, the Federal Aviation Act. This is the act that talks about airspace and commercial flight. The FAA, and also the agency, the FAA that is created under this act, it says that the federal government expressly preempts any legislation in this area. So states can't have their own local or state laws that regulate airspace, right? This is for the purpose of uniformity. We don't want different laws that kick in as airplanes are flying over different states. It would not allow us to have air travel, right? That would, the compliance burden, the regulatory burden would be too great, and it would pose a safety risk at that point. So the federal government passed regulations on commercial flights and on airspace in general, and said, this is it. You comply with this. We're not going to have any other laws in this space. And so again, that's done for uniformity purposes. But there can also be implied preemption. Even if Congress doesn't say it, the courts have sometimes found that that the federal government preempts the entire area. So an example would be if there could be a conflict that where you could not comply with both the federal and the state regulation at the same time. So I have here as an example the FMVSS, the Federal Motor Vehicle Safety Standards. We don't want different standards for every single state. So we have one federal standard that says that provide regulation in the area of automobile manufacturing. So these are the rules that tell us that we need seat belts, that we need blinkers, that we need a steering wheel, and provide the rules and regulations on how a car is manufactured. Can you imagine if there were different safety standards for every single state? It would be really impossible. So the federal government has enacted these safety standards on how cars must be manufactured, and they didn't include an express preemption. But the Supreme Court, the judiciary branch, has found that we cannot have individual states regulating in this space. So it's implied that there's just going to be one set of rules to comply with in this area. It can also be implied by the entire field. So when a federal regulation is in a particular area is just so comprehensive, if the laws are so comprehensive and pervasive that there's not really room for the states to regulate in that area, even if there's not a direct conflict, the courts have found that there's preemption here, and the states will not be allowed to pass laws. So immigration is an example. Congress has passed so many laws on immigration, and this is within the the Congress's purview. This is an enumerated power, right? This is international commerce. And so Congress has really thoroughly regulated all the aspects of this area and immigration. So even though there can be immigration that is intrastate travel, people crossing the border into states, and a lot of states want to pass their own rules on immigration, it's just not allowed. This is an area. This is an area where the Supreme Court and the judiciary has said there is implied field preemption, and even if there's not a conflict, even if there's not an actual conflict, states are just preempted from being in this space at all. So again, preemption means that only the federal government can act in this space, and it can be express, like written into the statute itself, or it can just be implied by the nature of the issue. Either there's a conflict between the state's laws and the federal laws, or it's just the nature, like immigration, the nature of the situation. Congress is so comprehensively passed legislation in this area that they're just not going to allow the states to step in and do their own thing. So that's preemption. And again, the purpose is for uniformity. We preempt in areas where it makes sense to have one standard across the country. Now, that being said, we don't always preempt. Sometimes we do allow states to act in the same area as the federal government. It really just depends. So an example would be the environment. So we do have, the Clean Air Act, the Clean Water Act. Congress has passed a minimum floor when it comes to things you can't do in terms of pollution. But states can go above and beyond that. Because if you have a power plant, if you have a manufacturing facility, by its very nature, it's just going to be in that state, right? So we're not creating standards that are like manufacturing vehicles where you're trying to comply with 50 different states as you manufacture a single car and you don't know what to do. A manufacturing plant that is polluting a river is in just one state. So it would need to comply with the federal government, and it's fine for the state to also regulate within its territory. Again, in this situation, the federal law will basically act as a floor. You can't go below the federal government, but if the states want to create more stringent requirements, and it's not a situation where there's preemption, yeah, we'll allow that. Another example, besides environmental protection, we've talked about minimum wage. The federal government can set a minimum wage. If the state wants to go above that, that's fine. They can do that. They just can't go below, right? That would be a conflict. If the state said you can pay $6 an hour and the federal government says you must pay $10 an hour, that's now a conflict. That law is not allowed. But if the state wants to say you have to pay 12, well, sure, you can comply with the state and you'd still be complying. You'd still be complying with the federal government. So that would be allowed. So in some places we do have concurrent powers. It's really going to kind of depend on what the topic is, what the area of regulation is, and we still fight about it all the time. Some states will say absolutely not. This is a states right issue. This should be concurrent power. And the federal government might say, nope, preemption, and they will fight it out in the courts, sometimes all the way up to the Supreme Court, and the courts will establish whether this should be a concurrent power or whether there is preemption. So when we have federal regulation, why do we do that? Why do we preempt and only allow the federal government? Well, it's nice, again, to have uniformity. It's for a national business, it's hard to comply with 50 different standards, and so it's nice to know here's the one standard that we need to meet. And then some issues are just too large scale for the individual states to take it on. So trade with other countries, for example, that's not something the state should be involved in. That's a big issue that has national effects. We need the federal government to handle this. Or defense, right? We would not want to leave it up to the individual states to defend our country. So that's something that we're going to leave to the federal government. Some things just make sense to regulate at the federal level. On the flip side, some things make sense to regulate at the state level. With when the state regulates in an area, they can really tailor those solutions to whatever their local needs happen to be. It tends to be more local, so states can prioritize what makes sense for their area. So they might prioritize agricultural regulations, while other states might focus more on like tech related regulations, just depending on what their state economy looks like. So you can get really more bespoke, tailored, personal types of regulations that make sense for the area that they're in. The second reason that we like state regulation is that we get to experiment. We call the states the laboratories of democracy. So it's a little lower stakes to pass a law in a state that's not 350 million or whatever we're at in the entire country. So you can try different things, and we've seen some really interesting types of policies that if they're popular or if they're successful, other states will start to pick up, or perhaps the federal state will start to pick up. So an example of this it was Massachusetts. They basically passed the equivalent of the Affordable Health Care Act, which required their state's citizens to have health insurance, and then had a state health exchange where people who couldn't afford private health insurance could purchase with the help of state funds. And so that worked really well, and that became the basis for the Affordable Care Act, the ACA, also known as Obamacare, which was then passed at the federal level. And so sometimes we can try things out and try new things at a state level, and if it's successful, we can model it in other places. And finally, state governments are closer to the people. We have an example here of people going to go see their mayor. They just have a better feel for what their people need, because it's smaller and they spend more time in their community. And so these are some of the advantages and why we leave some things to the state as opposed to giving everything to the federal government. So, a federal system where we have the national government and then the individual state governments can really work for a lot of reasons. We're able to send the things that make sense on a national scale to the federal government and keep things that make sense at the local scale for the local governments and the state governments. That works really well. But there are challenges. It's not the easiest. We have, regulatory uncertainty. As much as we try to avoid having conflicts, we have them. Sometimes we're not sure legally if something is a concurrent power or a preempted power, where it stays with the federal government. And so until we get an answer from the court, people and businesses can be really, confused, and there can be uncertainty as to which one of these am I supposed to comply with if there is a conflict. There's often legal disputes, right? So this takes up a lot of political energy. States challenge federal law all the time, saying this is not an appropriate place to act. This is for the states. And the federal law, does the same thing. We have seen on the southern border, states try to step in and make some laws related to immigration, and the federal government will sue. And so we have a lot of legal challenges in this space. Same thing when we passed the Affordable Care Act at the national level. A lot of states sued, saying that the federal government had overstepped their bounds. So we spend a lot of energy, a lot of political energy, a lot of money, because we have these two systems, and there are some gray areas where they meet. And finally, we just get changing national priorities. So we have, political shifts at the federal level can result in really, huge changes to the regulatory environment. And this can affect how state regulations are enforced or developed. So these things, the federal government, really can have a huge effect on state law and state regulations as well. Okay, so really to bring all this home, I hope by now that you really understand the distinct roles of state and federal regulation. They both have their place, and you're going to see them really, to see the difference in these areas when we talk about how automated vehicles are regulated. And you're going to understand why some things are done at the state level, why some things are done at the federal level. And you're going to see we don't have a lot of action really on some things at the federal level. There's a lack of regulation. And you're going to understand why states just don't step in and do it for them. Because there are certain things that are left to the federal government and other things that are left to the state government. You also now hopefully understand the difference between the branches and their roles in regulation. So you're going to understand, when Congress hasn't passed a law, why doesn't the president just issue a directive? Or why is something being overturned by the Supreme Court and what effect does that have on us? You're really going to understand when we start talking about how automated vehicles are regulated and some of the challenges that we're facing. You're going to understand why those challenges exist. So understanding the balance between the levels of government and the branches of government is really important to understand how you're regulated and also how these regulations might change in the near future. So I hope you enjoyed this section on the allocation of regulation.